In the early morning hours of July 31st, 2022, a surveillance camera mounted inside a quiet business park in Strongsville, Ohio, captured something that investigators would later describe as one of the most chilling pieces of evidence they had ever reviewed. A 2018 Toyota Camry entered the frame, moving at a speed that made no sense for the road it was on. And then, rather than slowing down, it accelerated. What happened in the next few seconds ended 2 lives, sent shockwaves through a community, and eventually landed an 18-year-old girl inside one of Ohio's most secure women's correctional facilities. That part of the story most people already know. What they don't know is what happened after the cell door closed. And that is where things get deeply unsettling. If you are new here, make sure you subscribe to DAV Crime Records and hit that like button right now, because we go deeper than the headlines, and this case is no exception. The name Mackenzie Shirilla became nationally recognized almost immediately after her conviction. She was 17 years old on the morning of the crash. By the time she sat in a Cuyahoga County courtroom to hear her sentence read aloud, she had just turned 18. The judge handed down 15 years to life. Mackenzie was sent to the Ohio Reformatory for Women, where she would remain for a minimum of 15 years before she could even appear before a parole board. For most people following the case, that felt like the conclusion. A verdict had been reached. A sentence had been imposed. Justice, at least in a legal sense, had been served. But the story did not end there. In fact, in many ways, it was only beginning. Before we go inside those prison walls, we have to go back to the moment that made all of this possible. Because this story does not belong only to Mackenzie Shirilla. It belongs first and foremost to 2 young men whose names deserve to be spoken clearly and remembered. Dominic Russo was 20 years old. Davion Flanagan was 19. Dominic was sitting in the front passenger seat that morning. Davion was in the back. They had families who loved them, people who depended on them, and decades of life ahead of them. None of that mattered to whatever was happening inside that car as it accelerated toward a brick warehouse wall on Progress Drive. The black box recorder inside the Camry told investigators everything they needed to know. The vehicle reached 100 miles per hour in a posted 35-mile-per-hour zone. The accelerator pedal was pressed to 100% throttle and held there for 5 full seconds, leading directly into the moment of impact. There was no braking. There was no swerving. There was no attempt to avoid what was coming. The car struck the brick wall of the warehouse in a direct, straight-line collision. Dominic Russo and Davion Flanagan were killed instantly. Mackenzie Shirilla survived. The defense presented at trial was built around a medical emergency theory. Mackenzie's attorneys told the court that she suffered from an undiagnosed condition that caused her to lose consciousness while driving. They argued she had no memory of the final moments before impact, that she had no intention of hurting anyone, and that what appeared to be a deliberate act was actually a tragic and unforeseeable medical crisis. It was a serious argument, and the court took it seriously. But the prosecution had evidence that pushed back hard against that explanation. Accident reconstruction experts took the stand and walked the court through the black box data point by point. The car did not drift. It did not veer unpredictably off course the way a vehicle might if a driver had suddenly lost consciousness. To navigate a curve at that speed and keep the vehicle on the pavement required active steering input. That means corrections. That means a driver responding to the road in real time. The prosecution argued that the 5 seconds of sustained full throttle, the precise straight-line approach to the wall, and the absence of any braking or evasive action all pointed to something far more deliberate than a medical episode. Their theory was that this was an intentional act, one rooted in the volatile emotional dynamics of Mackenzie's relationship with Dominic Russo. The case was decided in a bench trial, meaning there was no jury. Judge Nancy Russo of the Cuyahoga County Common Pleas Court evaluated all of the evidence herself and delivered the verdict: guilty on all 12 counts. 4 counts of murder, 4 counts of felonious assault. And from the bench, Judge Russo said something that stopped the courtroom and later echoed across every major news outlet covering the story. She said, "Mackenzie had a mission, and she executed it with precision." The sentence that followed was swift and severe. 15 years to life on each murder count, running concurrently. Mackenzie Shirilla, barely 18 years old, was transported to the Ohio Reformatory for Women to begin serving what could become the rest of her life behind bars. That is where the story was supposed to settle. A crime had been committed. A court had rendered judgment. A young woman had been removed from society and placed inside a correctional facility to face the consequences of what a judge determined to be deliberate, calculated violence. But correctional facilities keep records. They document behavior. They log violations. And when the state of Ohio unsealed internal conduct reports from the Ohio Reformatory for Women, what those documents revealed was something that nobody following this case from the outside had anticipated. The disciplinary file ran 36 pages, 36 documented conduct violations, 32 formal findings of guilt. These are not allegations. These are not rumors circulating on social media. These are official determinations made through the prison's own internal disciplinary process, reviewed by staff, and entered permanently into Mackenzie Shirilla's institutional record. And when you read through the specific nature of those violations one by one, a portrait begins to emerge, not of a young woman quietly serving her time and reflecting on what she had done. Something considerably more troubling than that. The violations range across a wide spectrum. Some involve what might initially sound like minor infractions: altered state-issued clothing, unauthorized possession of arts and crafts materials, including glitter and paint. Those items might seem harmless in any other context, but inside a maximum security correctional environment, they represent a deliberate rejection of the strict uniformity and control that allows a facility housing hundreds of inmates to function safely. Rules about personal items are not arbitrary. They exist because exceptions create problems, and problems in a place like that can escalate quickly. Then there are the repeated instances of being out of place during mandatory cell counts. If you are not familiar with how correctional facilities operate, the count is essentially sacred. Multiple times throughout every single day, every inmate must be in their assigned location so that staff can verify the full population is accounted for. Being out of place during a count does not just inconvenience a single officer, it disrupts the entire facility. And according to the logs, this is something Mackenzie did not do once. She did it repeatedly. But those infractions, as problematic as they are in an institutional context, are not the most serious entries in her file. Not by a significant margin. During an unannounced shakedown of Mackenzie's housing unit, guards conducted a systematic, cell-by-cell search without any advance warning to the inmates. What they found inside Mackenzie's cell crossed a line that prison officials treat as one of the most serious violations possible. She was in possession of another inmate's prescription medication. Prescription pills inside a correctional facility are not simply a rule violation. They function as currency. They are used as leverage. They create avenues for extortion, for debt, and for violence. The presence of someone else's medication in your cell is documented proof of involvement in exactly the kind of underground economy that prison administrators work constantly to shut down. The official record does not specify precisely how she obtained the medication, but the fact that it was found hidden in her possession during a surprise shakedown left no room for innocent explanation. And then there is the incident that triggered the unsealing of these records in the first place. The one that her mother took to social media to dispute. The one that cost Mackenzie Shirilla the single most important privilege available to someone serving 15 years to life. Guards assigned to monitor the facility's video visitation system observed explicit sexual conduct during one of Mackenzie's calls with an outside visitor. The official report entered into her disciplinary file states that she exposed herself during the call while the person on the other end was fully undressed and actively using adult toys. The call was terminated immediately. A Class 2 institutional violation was filed, and a 60-day revocation of all video visitation privileges came down without delay. To understand why this matters, beyond the obvious, you have to understand what video visitation means to someone in Mackenzie's position. For an inmate serving a minimum of 15 years, those video calls are a lifeline. They are often the only face-to-face interaction available with family, with friends, with anyone from the outside world. The system exists with a strict and non-negotiable rule, set precisely because monitored communication is how prisons prevent criminal coordination, protect staff, and maintain order among a confined population. Explicit sexual conduct on those calls is prohibited without exception. Not simply as a matter of decency, but because allowing that kind of material into a correctional environment creates pathways to extortion, to violence, and to the breakdown of the order that keeps hundreds of people in close quarters from descending into chaos. Mackenzie knew the calls were monitored. Every inmate is told, and she violated that rule anyway. While this disciplinary file was being compiled, while violation after violation was being logged and formally adjudicated, two families in Ohio were living with something no rule violation can begin to approximate. Dominic Russo's family does not have video calls to look forward to. They have a headstone. Davion Flanagan's family does not worry about prison privileges. They carry the permanent weight of losing a 19-year-old son who had no idea what was going to happen when he got into that car. Watching the person held responsible for those losses make headlines, not for remorse, not for rehabilitation, but for prescription pills and explicit video calls, creates a specific kind of pain that no amount of institutional language can adequately describe, and it is a pain that deserves to be named clearly, because this case has never been abstract. It has always been about two real people who are gone. Every single violation entered into Mackenzie Shirilla's disciplinary file becomes a permanent part of the record that a parole board will review when she reaches her 15-year minimum. The board will evaluate her behavior during incarceration. They will examine her attitude toward authority. They will look for genuine evidence of rehabilitation and an understanding of the seriousness of what she was convicted of doing. Right now, that file contains 32 formal findings of guilt, a revoked video visitation privilege, and documented possession of another inmate's controlled medication. That is not the record of someone who has reckoned with the weight of 2 deaths. That is the record of someone still in active conflict with the most basic structure of the life she is now required to live. The file is not closed. Appeals remain ongoing, and the pattern that prison officials have documented inside those 36 pages raises a question that no one has fully answered yet. Whether the behavior reflects genuine psychological unraveling under the pressure of a life sentence, or whether it reflects the same fundamental disregard for consequences that a judge described from the bench as a mission executed with precision. That question is still open, and there is significantly more inside those records than what has been covered here. The count is one of the most fundamental, non-negotiable realities of life inside any correctional facility in the United States. Multiple times every single day, every inmate must be in their assigned location so that staff can verify that every person inside that reformatory is exactly where they are supposed to be. When the numbers do not match, the consequences are immediate, and they ripple outward to affect everyone. Programs get canceled. Visiting hours get suspended. Movement across the entire facility freezes. Hundreds of women get locked inside their cells, not because of anything they did, but because one person refused to stand where they were told to stand. According to the official conduct logs, Mackenzie Shirilla did this not once, but repeatedly, and it did not stop there. The same logs document a sustained refusal to follow direct orders related to housing unit cleanliness and basic facility regulations. These are not complicated instructions open to interpretation. They are simple, direct commands issued by correctional officers whose entire job is to maintain order in an environment where a breakdown in structure can turn dangerous within seconds. Refusing those commands is not passive resistance. It is active defiance of the people responsible for keeping that facility functional and safe. And the record shows it happened again and again. When you place those documented violations directly alongside the public defense her family has mounted on her behalf, the contradiction becomes impossible to dismiss. Her mother has been visible and vocal. Social media posts have characterized Mackenzie as a misunderstood young woman simply trying to survive an unbearable situation. And from a parent's perspective, that instinct to protect and defend is completely understandable. No parent wants to accept the version of their child that an institutional record describes. But correctional officers are not filing 36 conduct reports out of personal animosity. They are not producing formal disciplinary documentation as part of some coordinated effort against a single inmate. The state's official paperwork exists because something generated it. And what generated it was a documented, sustained pattern of defiance that the facility had no choice but to address through its formal disciplinary process. Recorded phone calls between Mackenzie and her family, obtained by media outlets covering the case, offer a rare and unfiltered glimpse into her psychological state during this period. In those calls, she describes the experience of incarceration in ways that go beyond ordinary complaints. In one specific conversation, she tells her mother that she did not even know how to make a book stretch because there was simply nothing to do inside the facility. That is not a casual observation. That is someone communicating a level of mental and emotional desperation that the walls of a cell have a way of producing, particularly for someone facing not months, but decades of confinement. The boredom she describes is not the boredom of a slow afternoon. It is the boredom of a person staring down an endless corridor of identical days with no clear endpoint in sight. The prison administration's response to the pattern of violations was not sympathetic, and it was not designed to be. Under Ohio institutional rules, able-bodied inmates serving life sentences are required to work. The facility officially assigned Mackenzie a mandatory position as a food service worker in the prison kitchen. That means waking before dawn, working in a loud, hot industrial kitchen environment, serving meals to hundreds of other inmates, and cleaning heavy equipment at the end of every shift. For that labor, she earns the standard maximum inmate wage, which amounts to up to $24 per month. That figure barely covers the most basic commissary items. A few hygiene products, some packets of instant food. The message embedded in that assignment is not subtle. If unoccupied time is producing rule violations, the administration will eliminate unoccupied time. An exhausted inmate working a full kitchen shift is considerably less likely to be altering uniforms or concealing unauthorized medication during a cell block count. The structure of mandatory labor is being used as a direct administrative tool to interrupt the cycle of defiance that her conduct file documents so clearly. While all of this was unfolding inside the reformatory, the legal avenue that might have offered Mackenzie a path back to court was closing permanently on the outside. Her defense team had filed appeals, arguing that the original trial was flawed and that she deserved a new hearing, this time in front of a jury rather than a single judge. Those arguments made their way through the court system until they reached the Ohio Supreme Court, where they came to a final and complete stop. The court rejected her appeal, and the reason it gave was one that her legal team could not argue around. Her attorneys had missed the statutory filing deadline by exactly 1 day. The law required the appeal to be filed within 365 days of the verdict. Because of a leap year, the calendar contained an additional day in February that her legal team failed to account for. The filing arrived on what was technically the 366th day. The Supreme Court ruled that deadlines are not suggestions, that the rules exist and apply without exception, and declined to review her case. Every legal option for a new trial is now exhausted and permanently gone. The procedural facts surrounding that dismissal have generated significant online debate. Some legal observers argue that losing an entire case on a single missed calendar day represents a failure of process rather than a failure of justice. Others maintain that filing deadlines exist for a reason and that no exception should be made regardless of the circumstances. Both positions have merit within their own frameworks. But amid all of that procedural discussion, there is a reality that deserves to be stated plainly and kept at the center of this story. Dominic Russo's family does not have an appeal. Davion Flanagan's family does not get a procedural second chance. They do not get to argue before any court that the outcome was unfair or that the timeline should be extended. They mark anniversaries instead of filing paperwork. They carry permanent grief instead of legal strategies. While attorneys were calculating calendar days, those two families were living through another year without their sons. The closure of her legal options means that the only remaining path to release runs directly through the parole board. Her first eligibility date falls in October of 2037. At that point, she will sit in front of a panel that will have access to everything: the crash data, the trial record, the sentencing statement from the bench, and the 36-page disciplinary file from the Ohio Reformatory for Women documenting 32 formal findings of guilt, a revoked video visitation privilege, and possession of another inmate's controlled medication. Parole boards do not evaluate inmates in isolation from their institutional record. That record is the primary evidence of who a person has become during their time behind bars. And right now, Mackenzie Shirilla's record does not reflect someone who has absorbed the weight of a conviction for murder and responded to it with discipline and demonstrated growth. It reflects someone who has spent the early years of her sentence in sustained conflict with the most fundamental rules of the institution holding her. Every additional violation added to her file between now and October 2037 makes that parole hearing harder. Security classifications get downgraded. Commissary privileges disappear. Tablet access gets revoked. Video visitation, as she has already discovered, can be taken away entirely. The facility removes connections to the outside world, one by one, until compliance becomes the only remaining option. Whether that approach produces genuine behavioral change or simply forces surface-level compliance without addressing anything underneath it is a question the prison system and the people who study it have been debating for decades. There are people who look at the conduct violations in her file and argue that high-profile inmates are subject to heightened scrutiny, that correctional officers who recognize her name from media coverage may apply standards to her that would not be applied with the same consistency to someone whose case never made national news. That argument cannot be dismissed entirely without evidence one way or another. There are also people who look at the same file and see a continuation of the same fundamental pattern that a judge already identified in a Cuyahoga County courtroom. A person who does not respond to rules, to boundaries, or to authority the way the situation demands. Both interpretations exist, and both have been expressed loudly by people following this case from the outside. What the recorded phone calls suggest, when taken at face value, is that the psychological toll of confinement is severe and real. Describing an inability to make a single book last because the emptiness of the days is so consuming points to a level of mental and emotional strain that institutional environments are not designed to address with particular care or nuance. The question of whether correctional facilities should provide more structured programming, more educational resources, and more constructive outlets for young people serving life sentences is a legitimate policy conversation. The prison administration's position is equally straightforward. Their responsibility is security and order, An inmate who breaks a rule faces a consequence. That framework does not bend based on how bored or psychologically distressed an individual claims to be. With her appeals finished, her visitation privileges revoked, and mandatory kitchen labor filling the hours she described as unbearable, Mackenzie Shirilla now exists in a version of incarceration stripped of nearly every buffer between her and the raw reality of what a life sentence means. Whether the finality of her legal situation produces a turning point or accelerates the pattern already documented in her file is something that only time and the continued official record will answer. The parole board that convenes in October 2037 will not be making a decision based on what anyone says about her character. They will be making a decision based on what the documented record shows. And right now, that record is being written one violation at a time. The cameras that covered her trial are long gone. The courtroom arguments are over. The appeals process has reached its end. What remains is a 36-page file that keeps growing, 2 families carrying loss that never gets lighter, and a set of questions about punishment, accountability, and the possibility of genuine change that this case forces into the open without offering any easy answers. If this investigation has stayed with you, subscribe to DAV Crime Records right now and hit that like button so you are here when the next chapter of this story is documented. The file is still open, and we will be covering every development as it becomes part of the official record.